This morning, at precisely 10:03 a.m. Eastern, the nation's highest court issued a ruling so brief it almost felt unreal. 2 words, no explanation, no concurring opinions, no dissent, just a single line that brought months of legal maneuvering to an immediate stop. The application was denied. And with that, everything changed. What makes this moment so significant is not only the ruling itself, but what happened in the 72 hours leading up to it. Because just 3 days earlier, attorneys representing a former first spouse quietly submitted a confidential cooperation proposal to federal prosecutors. That submission outlined what evidence she was prepared to provide, what testimony she was willing to give under oath, and the conditions under which she would do so. 2 major legal events, 72 hours apart, and the timing is impossible to ignore. Before anyone rushes to dismiss this as rumor or exaggeration, it's important to understand where this information comes from. Court filings, formal agreements, official orders. These are materials entered into the legal record, not leaks, not speculation, not anonymous claims. Here is what is now legally established. The former first spouse voluntarily waived spousal privilege. That protection, which normally prevents one spouse from being forced to testify against the other, belongs to the witness alone. And in this case, the witness gave it up willingly. That decision opened the door to 3 categories of evidence, each more serious than the last. The first involves financial records, joint tax filings spanning multiple years, documents signed under penalty of perjury. These filings rely on declared asset values, properties, income streams, deductions. According to the cooperation proposal, she was aware that certain properties were valued one way when presented to lenders and valued very differently when reported to tax authorities. Think about that. If assets are inflated to secure favorable loans and deflated to minimize tax liability, that discrepancy carries legal consequences. And when those filings are joint, responsibility is shared, not once, not twice, but repeatedly over a span of years. The agreement states that she attended meetings with accountants where these valuations were discussed openly. Contemporaneous notes from those meetings already exist. Emails corroborate them. In some cases, she questioned why numbers presented to banks did not match numbers reported elsewhere. Let me read this part word for word. The agreement states that she raised concerns regarding inconsistent valuation methodologies prior to submission of financial documents. Read that again. Raised concerns prior to submission. The second category of evidence involves communications, messages exchanged ahead of lender meetings, emails with financial professionals discussing how assets should be described, text messages referencing upcoming loan applications, and recorded phone calls directly tied to those transactions. Now, here's the part no one expected. If recordings are included in a cooperation proposal, prosecutors have already verified their legality and authenticity. They don't speculate, they confirm. These recordings reference specific properties, exact figures, and timing that aligns with loan submissions already on record, not once, not twice, repeatedly. The third category is testimony. Her testimony would not stand alone. It would corroborate statements already given under oath by accountants, bankers, and property appraisers, multiple witnesses, independent accounts, matching timelines, supporting documents. In federal cases, corroboration changes the equation entirely. 1 witness can be challenged, 2 raise questions, 3, backed by documents and communications, establish a pattern. Buried deep within the cooperation proposal is the most consequential detail of all. The waiver of spousal privilege applies broadly, fully, without limitation. This is not partial cooperation. This is comprehensive. And it was not compelled. According to a sworn statement from her legal counsel, she initiated contact with prosecutors. No subpoena, no threat, no ultimatum. Her attorneys reached out first, proposed cooperation, and negotiated terms. That distinction matters. The defense team responded by filing an emergency appeal, arguing that this cooperation should be blocked. They raised three arguments. The first claimed that spousal testimony violated constitutional privacy protections, but decades of precedent say otherwise. The privilege belongs to the witness. If the witness chooses to testify, the other spouse cannot prevent it. The second argument alleged coercion, that prosecutors pressured her into cooperating. But the record shows the opposite. Her legal team initiated contact. The agreement includes sworn statements confirming the decision was voluntary. The third argument warned of a dangerous precedent, that allowing this testimony would erode marital privacy protections in future cases. But that precedent already exists. Spouses testify voluntarily in federal cases every year. What the defense was effectively requesting was an exception, not based on law, based on status. Courts do not grant exceptions like that. Which explains the ruling. No opinion, no dissent, no explanation. When the court issues a single-line denial, it sends a message. The argument wasn't just weak, it wasn't worth the court's time. With the appeal denied, the grand jury process moves forward immediately. No stays, no delays, no remaining privilege claims. Testimony can proceed, and it could happen very soon. Once that testimony is complete, prosecutors face a strategic choice. They can use the evidence to strengthen existing charges, or they can seek a superseding indictment, adding new counts based on newly corroborated facts. One conversation referenced in the proposal stands out. A phone call involving both spouses and a lender discussing property values prior to a loan submission. If both parties knowingly misrepresented information during that call, that opens the door to conspiracy allegations. Conspiracy is separate, more serious, and it carries its own consequences. The trial schedule remains unchanged. With no further appeals available, the timeline holds. Now step back and look at what this means. This isn't about one document. It's about behavior. It's about patterns repeated over time. It's about what happens when private decisions become public evidence. Ask yourself this: if this were anyone else, would the process look any different? Or is the system doing exactly what it's designed to do when institutions hold firm? Short sentences matter here. No one is above the law. Not influence, not wealth, not proximity to power. Over the next several weeks, three things will reveal the prosecution's direction: grand jury activity, defense motions, and whether a full immunity agreement is finalized. Each step will signal how strong the evidence truly is. Defense filings in particular will be telling. If they attack recordings, it's because the recordings are damaging. If they attack credibility, it's because the documents are solid. Legal strategy reveals pressure points. The court didn't need to explain its ruling because the law was already settled. Voluntary cooperation is allowed. Evidence will be heard. Delay tactics failed. The system moved forward because the institutions involved chose to enforce existing rules instead of bending them. That's the real story here. Not personalities, not speculation, process. And process matters. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it does.